11:47 p.m. on a Friday, the Supreme Court handed down a massive 127-page 6-3 ruling that strips criminal immunity protections from sitting and former president. Chief Justice Roberts and the majority delivered a clinical decision with a clear central message. The president is not a king, and no person in this nation is above the law. The case moved at an extraordinary pace on the emergency docket, bypassing normal procedures. Trump's team requested a fast-track decision on Wednesday, and by Friday night the final ruling was issued. Such midnight rulings are incredibly rare, signaling that the justices viewed this as an urgent constitutional crisis. Inside the text, the court methodically dismantled every defense advanced by Trump's team. On page 23, the majority stated that the president enjoys no immunity from the criminal process. On page 34, they rejected the official act's defense, determining that executive power can be preserved without protecting presidential criminality. The concurring opinions firmly established a new legal standard. The presidency is elevated, but it is not insulated. The three dissenting justices warned that the ruling is dangerous and will leave future presidents vulnerable to weaponized, politically motivated prosecutions. However, the majority countered that authority without accountability is precisely what the framers sought to prevent. The immediate fallout has fractured Trump's legal strategy. Within 12 minutes of the ruling, his team issued a fierce public statement, and by Saturday morning they filed an emergency motion for a stay. The Supreme Court denied that stay within 2 hours without explanation. Behind closed doors, advisors are split between trying to delay and pursuing settlement negotiations to limit exposure. With the immunity shield gone, federal prosecutions and state cases in Georgia are resuming immediately. Moving forward, the critical roadmap hinges on key dates. Formal legal briefs detailing Trump's next strategy are due by May 29th. Judges will issue new trial dates by June 2nd, and Georgia trial scheduling hearings will begin by mid-June. Constitutional law has changed permanently, and the entire legal landscape is now adjusting in real time.